Good afternoon, ladies and gentlemen. Welcome to the 7th International Conference on the Law of the Sea. My name is Kian Kim, and it is my great pleasure to be here with you today. I'd like to extend my sincere and our sincere gratitude to all the panelists and participants for joining us today at this conference today. And before we begin, I'd like to inform you that this conference will be held in hybrid format. As some of our panelists are joining us online, I kindly ask for your understanding on any technical issues that might rise. Now, let us start the conference under the title, The Law of the Sea for the Next Generation, Effectiveness of UNCLOS Revisited. To begin this conference, we are pleased to have the President, Albert J. HOFFMANN, from the International Tribunal for the Law of the Sea, to deliver his congratulatory remarks. Ladies and gentlemen, please welcome President HOFFMANN. Hello, President HOFFMANN, can you hear us?
Yes, I can hear you.
Thank you. Now is the time for your congratulatory remarks.
Thank you very much. Excellencies, distinguished colleagues and guests, good day to you all. Let me first express my regret from not being able to join you in person to participate in this year's conference. Due to unforeseen circumstances, I was unable to travel to Seoul. I'm nevertheless pleased to be able to participate online and also for the opportunity to address you today. It is an honor for me to provide some congratulatory remarks on the occasion of the 7th International Conference on the Law of the Sea, co-organized by the Ministry of Foreign Affairs of the Republic of Korea, the Korean Society of International Law, and the International Tribunal for the Law of the Sea. Since the first conference in 2016, members of the Tribunal have each year contributed to and benefited from the exchange of ideas on current issues in law of the sea. I wish to thank the Ministry of Foreign Affairs and the Korean Society of International Law for their initiative in organizing this event and bringing together this distinguished group of experts to discuss the effectiveness of the United Nations Convention on the Law of the Sea and the rule of law in the ocean. The topic of this year's conference builds on last year's focus on law of the sea for the next generation and looks in particular at the effectiveness of UNCLOS to date. As we face new challenges in global ocean governance and consider how the convention might adapt and evolve in the face of such challenges, I believe it is important to take stock and to reflect on the mechanisms available under the convention and what rules and procedures are already at our disposal. This conference provides a valuable opportunity to look at how the convention has been interpreted and applied by judicial bodies and how those decisions have been received, so as to better understand how the law of the sea can most effectively ensure the rule of law in the ocean, not only in the current era, but also for the next generation. I welcome in particular the inclusion of the panel on Thursday entitled Voices of the Next Generation. I wish to commend the initiative of the Ministry of Foreign Affairs and the Korean Society in including the next generation of legal scholars in our discussions. I look forward with interest to hearing their views and perspectives on the effectiveness of the convention, also in confronting the challenges ahead of us. The starting point for our discussions is a review of the judicial decisions made under the UNCLOS regime. Thus, we can consider the jurisprudence of the International Tribunal for the Law of the Sea, as well as that of arbitral tribunals established pursuant to Annex 7 of the Convention. While the International Court of Justice has not yet dealt with a case where its jurisdiction was established on the basis of Article 287 of the Convention, it has interpreted and applied the provisions of the Convention on numerous occasions, most recently in the Somalia versus Kenya maritime delimitation case. When the UNCLOS dispute settlement system was established, concern was expressed that the existence of multiple judicial bodies for the settlement of disputes arising under the convention might lead to the fragmentation of the law of the sea, with different judicial bodies adopting different approaches to the same legal issues. There was a fear that offering states a choice of dispute settlement mechanisms might undermine the effectiveness of the rules set out in the convention. I think it is fair to say that such fears have turned out to be unfounded. While there are nuances in approach, for the most part, the decisions of the various UNCLOS judicial bodies have complemented each other and have led to the creation of a body of consistent jurisprudence on various law of the sea issues. Looking more closely to the decisions of the International Tribunal for the Law of the Sea, there can be no doubt that in interpreting and applying the convention, the tribunal has contributed to the more effective implementation of the law of the sea. The tribunal has built upon existing jurisprudence, including that of the ICJ, thus ensuring stability and predictability, while at the same time taking an innovative approach when necessary, contributing to the development of the law. From its initial case law on the arrest and detention of vessels and crews, in which the tribunal provided valuable clarification on the issue of the nationality of ships and developed the notion of ship as a unit, the tribunal has gone on to deal with important aspects of resource exploitation, whether fisheries or the non-living resources of the area, as well as the protection and preservation of the marine environment. The tribunal has also made important contributions to the law of maritime delimitation, and I look forward to the panel discussion in this regard. In my view, the two advisory opinions delivered to date, that of the Seabed Disputes Chamber regarding the sponsorship of activities in the area, and that of the tribunal as a whole relating to issues raised by illegal, unregulated, and unreported fishing, are of particular relevance when considering the effectiveness of UNCLOS and how the law of the sea might evolve in future to ensure the rule of law in the oceans. If we take the example of the advisory opinion of 2nd April 2015, delivered in response to a request by the Sub-Regional Fisheries Commission, here the states concerned were facing a serious and well-documented problem in global ocean governance, that of IUU fishing by third states within their EEZs. The members of the Sub-Regional Fisheries Commission sought guidance on how the convention applied to this situation, including with respect to the obligations of flag states. Now, I know that Professor Nilufer Ural will discuss this case in more detail during the session on advisory proceedings. I would only wish to remark that the issue of flag state responsibility for IUU fishing activities, although not directly addressed in the convention, was examined by the tribunal in light of general and specific obligations of flag states under the Convention for the Conservation and Management of Marine Living Resources. The tribunal clarified that all flag states are under a due diligence obligation to take all necessary measures to ensure compliance with relevant laws and regulations and prevent IUU fishing by vessels flying its flag, and that the flag state can be held liable if it fails to comply with its due diligence obligations concerning IUU fishing activities. So by clarifying the legal obligations of flag states, the tribunal has enhanced the effectiveness of the convention. It has also facilitated the possibility of a future contentious case involving flag state liability for IUU fishing. I believe that advisory opinions thus have great potential to address other pressing ocean governance issues. As you are no doubt aware, momentum is currently building around the need for an advisory opinion on climate change mitigation, both as a matter of general international law before the International Court of Justice and in relation to the law of the sea in particular before the tribunal. Climate change is undoubtedly one of the major challenges facing the marine environment. The political declaration adopted by the UN Ocean Conference in Lisbon in June earlier this year noted that the adverse effects of climate change on the ocean and marine life include the rise in ocean temperatures, ocean acidification, deoxygenation, sea level rise, the decrease in polar ice coverage, shifts in the abundance and distribution of marine species, including fish, and a decrease in marine biodiversity. We also heard from world leaders and experts at the climate summit currently in progress in Sharm el-Sheikh, Egypt, sounding the alarm on the harsh climate realities facing our planet and the existential threat sea level rise poses to small island states and coastal communities. Although the convention does not contain any provisions especially addressing the issue of climate change, it is possible that the tribunal may be called upon to clarify the legal obligations imposed by the convention on states to protect and preserve the marine environment, and for states to take all measures necessary to prevent, reduce, and control pollution of the marine environment from any source, including land-based sources, and to ensure that activities under their jurisdiction or control are so conducted as not to cause damage by pollution to other states and their environment. By taking into account internationally agreed rules, standards, and recommended practices, such clarification should be relevant, in particular to the question as to whether greenhouse gas emissions could fall within the remit of the provisions of the convention when they cause or are likely to cause marine pollution. Another challenge facing the law of the sea is that of the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, or BBNJ. It appears that efforts to finalize the text of an international legally binding instrument on BBNJ are finally beginning to gain ground. If agreement can be reached, the final text is likely to consist of a careful balance of different interests. As with the convention itself, dispute settlement will have an important role to play in ensuring the effectiveness of the new instrument and its adequacy to deal with future challenges. Here again, the past practice of the tribunal indicates that advisory opinions could be a useful tool. Finally, last week, the conclusion of meetings of the Council of the International Seabed Authority as part of its 27th session, states have expressed diverse views on the timing of the adoption of the regulations on the exploitation of mineral resources in the area, with some states calling for a precautionary pause. Several states have raised the idea of requesting an advisory opinion from the Seabed Disputes Chamber regarding the interpretation of the so-called two-year rule relating to the adoption of the exploitation regulations. While it remains unclear as to whether states will request such an opinion, I believe it provides an interesting example of the potential for the tribunal to assist states not only with substantive law of the sea questions, but also with more procedural issues relating to the functions of regulatory bodies created under the convention. With this brief consideration of how judicial bodies created under the convention might enhance the effectiveness of UNCLOS in future, let us turn to the core focus of this conference, that is the review of judicial decisions made under the regime set out in the convention. Excellencies, distinguished guests, it remains for me to reiterate the tribunal's appreciation to the Ministry of Foreign Affairs and the Korean Society of International Law for co-organizing what I am sure will be a most stimulating and informative conference. I look forward to the interesting discussions ahead, and I thank you for your kind attention.
Thank you very much, President Hoffmann.